Hi, Tony DeWitt here. I'm a retired Missouri appellate attorney, and I like to make the law make sense. So if you'd like for the law to make sense, stay tuned. One of my subscribers was kind enough to ask me to do a review of Marcellus Williams' case. Marcellus Williams is a Missouri inmate who is facing execution on September 24th. Although I do not necessarily believe that the death penalty is an effective deterrent, or that it is always administered properly, or that there are not mistakes made, due process is served when a person has every opportunity to present his claim of actual innocence and doesn't make the grade. So let's review a little bit procedurally. I did a review the other day of the criminal process, but during the trial, the state has the burden to prove that he actually committed the crime. Here is the evidence that they presented in short form of what happened. First of all, the crime is so graphic that I dare not describe it in the way that the opinion from the Missouri Supreme Court does. It is a truly graphic and horrifying crime that was essentially done to steal a laptop and some jewelry. The young lady who was murdered in the case was stabbed 43 times, and I'll leave it at that. The laptop was found to be in the possession of Williams before he sold the laptop, and the police found the person that he sold the laptop to, and that person came into court and testified, yeah, that guy over there sitting in the defendant's seat, he's the guy who sold me the laptop. In addition to that, his girlfriend at the time was a lady by the name of Asaro, and Ms. Asaro found the victim's purse in Williams' possessions. And I think, like most women would, he wanted to know what her boyfriend was doing with some other woman's purse. And according to the opinion, he confessed to her. One confession, however, is not enough. He then later confessed to a cellmate that he had done the crime that he was charged with. In addition to all of these things, he attempted to escape from the city workhouse, it's essentially, because St. Louis City is a statutory county in Missouri, they call it the county workhouse, but it's in the city of St. Louis. And he did that, one assumes, because it wasn't because he was unafraid of being convicted. Obviously, he was afraid he was going to be convicted, and he fled because he had consciousness of guilt. I think that's a reasonable inference that can be drawn from that evidence. So that was everything that happened in the case. He was convicted. The jury recommended the death penalty, and the court imposed the death sentence. It was reviewed by the Missouri Supreme Court, and you can read the opinion here. It's State v. Williams, 97 Southwest 3rd, 462. It's a 2003 case, and it's available on Justia and Case Text. If you just Google the above citations, you'll find the case, and you'll read what the story is. In addition to that, there are two later cases that can be found through the Missouri court system. That is www.courts.mo.gov. And those cases lay out the procedural history in this case. Not only did Mr. Williams have a direct appeal, which was denied, he then filed for post-conviction relief. That was denied, and that was appealed, and that was denied. He then filed a writ of habeas corpus. And his allegation in the writ of habeas corpus was that he was entitled to DNA evidence to show that he was not a source of DNA on the knife that was recovered at the crime scene. So, as a result of that, the Missouri Supreme Court, acting on that writ, said, okay, you're right. You can have all of the DNA testing that you request to attempt to prove your actual innocence. So he got all of the DNA testing, and he sought a second writ to get out of jail to essentially assert that he had been wrongly convicted because his DNA wasn't there, and that was denied. Then, after that, he was set to be executed, and the prosecutor in the case essentially filed a motion to vacate the conviction because the prosecutor, who is now the Democrat nominee for the First Circuit, not the First Circuit, the First Congressional District in Missouri, Wesley Bell, doesn't believe in the death penalty. And as a result of that, he filed this motion to vacate the conviction through the special procedure that they have through their Conviction Integrity Project. And I'm sure Mr. Bell did an absolutely marvelous job of putting together everything to show that Marcellus Williams didn't do this horrible crime. But at the end of the day, it fell short. And just a few days ago, it was denied by the circuit court in the city of St. Louis. And as a result of that, Mr. Williams is going to have a date with the executioner. Now, if you look on the internet and you Google his name, you will find all kinds of advocacy programs, including the Innocence Project and including the Death Penalty Project, all touting what a tremendously wonderful guy this fellow is and how he didn't do this, and numerous claims that he is not responsible for this crime. The only problem with that is that it ignores all of the evidence contained in the opinion that is the Missouri Supreme Court's opinion. It doesn't counter any of that evidence. Essentially, it does not show that he did not commit this crime. There has to be a showing of factual innocence in order to get somebody out of jail, in order to commute their sentence, vacate the conviction, all of that. And he did not make that burden. Now, the prosecutor presented this, the state opposed it, and he lost. He has had every bit of due process that he is due. It went up to the United States Supreme Court not once but twice, and he lost both times. In fact, the procedural history is included in the last ruling that the court made on his writ. This court affirmed Williams' judgment of conviction and sentence in 2003 and the judgment overruling post-conviction relief in 2005. Williams filed a petition for habeas corpus in federal court. The federal district court granted relief, but the Court of Appeals for the Eighth Circuit reversed the judgment and denied habeas relief. The United States Supreme Court denied Williams a petition for a writ of certiorari. This court set a January 28, 2015 execution date. On January 9, 2015, Williams filed a petition for a writ of habeas corpus in this court. This court vacated the execution date for additional DNA testing and habeas proceedings and appointed a special master to ensure complete DNA testing. After receiving the special master's report, this court denied Williams' habeas petition. The United States Supreme Court denied Williams' petition for a writ of certiorari. This court set an August 22, 2017 execution date. On August 14th, Williams filed another petition for a writ of habeas corpus, which this court denied. The United States Supreme Court denied Williams' petition for a writ of certiorari. On August 22, 2017, the former governor issued Executive Order 1720, appointing a board of inquiry pursuant to 552.070 and staying Williams' execution until such time as the governor makes a final determination as to whether or not he should be granted clemency. That was the executive order. In 2023, the governor issued an executive order rescinding the executive order, dissolving the board of inquiry, and removing any legal impediments to the lawful execution of Marcellus Williams. Williams filed the underlying declaratory judgment action alleging 4 counts: violations of due process, violations of federal due process rights under color of state law, that the governor lacked authority to dissolve the board of inquiry, and that the executive order violated constitutional separation of powers. Williams also filed discovery requests with the petition. The governor filed a motion for judgment on the pleadings and a motion to stay discovery. The governor's motion for judgment on the pleadings asserted Williams had no due process interest protected in the clemency process, and the governor also asserted Executive Order 2306 did not violate the statute and argued that Williams' statutory claim fails as a matter of law. The circuit court overruled the governor's motion for judgment on the pleadings with respect to counts 1, 2, and 3, and stayed discovery for 2 weeks. The circuit court concluded Williams had a due process right to demonstrate his innocence. The circuit court concluded the governor had no authority to dissolve the board. The governor petitioned for a writ of prohibition or mandamus. This court issued a preliminary. It will come as no surprise to anyone that the court made its writ of prohibition permanent, and it essentially said the circuit court had no discretion to do anything but grant the governor's motion. And thereafter, the execution date was set for September 24th of 2024. As you can see, Marcellus Williams has been given the benefit of a great deal of due process. Multiple courts, multiple judges have looked at the claims of factual innocence, and they have found them wanting in every respect. And so it would appear that the execution is going to go forward and that the law has been satisfied. Now, Marcellus Williams doesn't like that, and I'm sure his family doesn't like that, and I'm sure his lawyers don't like that. But there has to come an end point in litigation. Every case comes to an end. And when it does, that's the end. Unfortunately, it's also going to be the end for Marcellus Williams. But then again, when you commit a crime and he has been convicted by a jury of his peers of doing this awful thing, you deserve some punishment. And the jury in this case felt like it was heinous and awful, and as a result that he deserved the ultimate punishment. And in this country, we tend to respect the judgment of juries. So that's what I have for you today. It's not exactly a fun case to talk about, but it does set forth an interesting review of the procedures, again, that I talked about in the last video, about how the court system is used after conviction to lengthen the amount of time that somebody spends on death row and prevent, as long as possible, their date with the Grim Reaper. So if you've enjoyed this, I'd love to have you put a like down there, subscribe. If you have any questions or comments, drop them down below, or you can email me at the address above. Thank you again for watching, and stay tuned for the disclaimer. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. So please don't take anything I say here as legal advice, and if you need legal advice, see a lawyer in your jurisdiction. And keep in mind that if you don't have money for a lawyer, if there isn't a legal aid society that can help you, often law schools have clinics where student lawyers can represent you in court, and often they do an awesome job. And here are some videos that YouTube thinks you may enjoy.